What? Red pen.
Racism, epistemology, EDA, patriarchy, citizenship argument, as you said. And then states.
Which one are you doing with
What's up?
that? Who are you doing with that?
Yeah, for sure. Legitimacy. Then, legitimacy, racism, epistemology, ADA, patriarchy. Then your citizenship argument.
Yeah.
Yeah.
Okay.
And then the county.
Jim C. Section 272 our West Central West indicated we would redefine justice and our city department. Ace point indicates that the plan is a paradigm shift in legal jurisprudence between city races, all contemporary problems with the equal protection clause by imagining it is applying to all people indicates that utility is not a key question. We have to both just additionally extend our rule of law's exclusionary argument. When I say impact proves that we are a global approach to striking down a specific law that denies equality is one that allows equality for women globally, worldwide, which means that there is a citizenship and state argument that allows the Morrison president to continue to deny millions of women. Additionally, our implied the global argument is still over and it's critical to activism and see the Human Rights Watch amongst the racism debate. The topic can't solve this through the counterplan that doesn't spill over to state action. The counterplan only applies to violence against women. The Morrison precedent applies to violence against everyone and upholds bad precedents that Jim Crow precedents, including the civil rights case, the Cruikshank case, and the Harris case, in which we have isolated specific internal links to racism. Our regard to evidence indicates that racism in the law will always be a losing battle as long as Morrison stays on the books now. They're often they didn't spend enough time here to win any of it. Group extend our one and single regard to evidence indicating that criminal justice works, which means we ultimately provide a choice and we can't exclude minority women. Maybe we just can't help them as folks in the 2C goal for our evidence. And when I say evidence, I think that we allow an examination mix motives through the remedy and the remedy cause a fact-finding situation which acknowledges intersectional oppression. Additionally, Morrison struck down analogies between race and gender, which means that even if the remedy doesn't necessarily solve the Morrison decision, links to their argument more. Additionally, movements to be able to spill over the epistemology argument that you can't solve this at all. Our resident evidence is about the Morrison decision drawing gender lines. Ace appointed draws the line between the state and the federal, which the counterplan continues to draw in. These other books, Ace appointed draws the line about gender neutrality. They might solve neutrality. They cannot solve the line about the state and federal. Senator Peterson Evans to give the epistemology as prior question, how we know how we shape problems, actors, and solutions to solve. Is on our students' evidence is far more specific because it's about how college students think they see their type of evidence and the impact is because it failed to acknowledge our gender lens as a failure to acknowledge that peace is war, that 19 million people are dying due to structural inequality, and only the permutation solves this. Is their 1 and C evidence. Resident to the arguments not federal law courts and the optimal rights made, including subject quality, fair simply defense for some effort to they don't see principle of let's say plus organization principle cannot assume that any specific jurisdiction of the family, the state, the nation, the globe is necessarily a state power. Equality is not an artifact of a certain level of power, but who have that power and how it is used. The ADA advantage they can't solve this advantage because it's based on striking down the ADA based on the Morrison precedent. Step 1, almost 7 states of Garrett 1 and 2 have already decided in a way that have heard the social remedy of the ADA is perceived, which means that we actually solve their perception arguments. So states won't be able to enforce them even if the remedy is in itself struck down. States know that the Morrison precedent defends them for not enforcing laws that are already on the books. Extended to a series indicates that the ADA is already hollow right now. They exceed our internal link indicating the social remedy is key to the entirety of the ADA. Like exists, but the only important part of it is the one that acknowledges the disability. It's not something that needs to be treated. The impact is medicalization, genocide, and state challenges still over later. And the court should continue radical conversation about the facts and sufficient give authority to guarantee equal protection according to the challenge court legislation in states. Life of beauty, security, police, probation, and ADA to one future challenge protection monetary team of states under ADA Title 3 now. The patriarchy advantage group, all their evidence are not unique and the inherency evidence for us to class co-excludes citizenship. Additionally, we can add that our unsafe link arguments about how more sensitive and patriarchal trust lines between state, family, and private law indicates that violence against women is always something that is in the fact there was always opposition from the state courts and the legal judges when the vow was presented because they knew that it was an attempt to shift their culture. Additionally, consider substance of equality over car science indicating that more citizens and forms now the equality. Additionally, we control the internal link and all their global evidence, articulate evidence indicating that domestic denial of equality spills over. It affects our conception of international relations. Additionally, our Rogalski evidence and Peterson evidence solves our argument because we are a gender lens that can solve any of the problems with the international lens of West evidence extend religion and science extend we can have solve indicating that only 14th Amendment guarantee can break down state impunity, which is linked to now citizenship rights extend all of the 2AC evidence group here. A split our ethics argument is unique to their terms, indicating that our conception of citizenship is based around ethics, which means it is and care for the other, which does not allow exclusion of the other. At this point, we are starting for decision, which means we allow to be explained. They conceded the 1AC. The 2AC was always about global law. Additionally, law is critical. They conceded our argument about how that law being counsel and Morrison is a isolationist resident of logical local protection, Morrison protection from the term put on Balkans, national standing, full government, shelter, class from about national laws and vows about the international plan for national laws and international laws, local get things one close and for about 2 countries and practice and practice of policy. Local law making decision decide group the overview the argument is incoherent. National citizenship is bad because of exclusion. That is what Morrison said. He used national citizenship to exclude it. We overrule the Morrison decision and say that everyone is part of the club. The Carolina links to start the A split and reads argument about how the states are more exclusive of their citizenship. These point their only link argument is about the civil remedy, which means that the counterpoint adopts it. Sees point Morrison in no way links this argument over. Morrison is separate from reinstating the remedy. The plan has 2 parts and they don't access the link to the differential between the plan and the counterplan. The link to figure there's no link to our national identity argument. All of their laws link evidence assumes that we read a disintegration civil war impacting one is the not equality breaks woman. Additionally, straight turn all of their link packs at a point that identity argument explained well. B point their Bosnian evidence was guaranteed. Their Bosnian evidence concludes that Carst's analysis of substantive equality is important to overcome the problems with equality citizenship. Additionally, their next argument is perception. We control perception. They see the 2C gold for evidence indicating that all subsequent reforms were influenced by the perception of the Morrison decision. Said our vow as a starting point evidence. Additionally, immigration rights arguments. We solve immigration rights in 14 conceptions. Inclusionary Z load of 3 to speak for the local reflex and not something joints and perfected court of size. Case power dota broke fifth not some like the court's voting power keeps base rights and not inclusionary scope. There's no impact. This argument that outweighs or turns case or access to any of our advantages now. The state's care plan doesn't solve this plan on the advantage page. We see a funny argument about how they can't solve jurisdiction because states don't enforce them to make their evidence for the 2C indicating that ultimately congressional action can cause states enforcement, which means that even if they have state court ruling, state legislators won't respond to those rulings in states are different remedy. Extend the gold programs from the 2C, extend our legal culture evidence, our wise evidence indicating that you have to change the culture in the states before they can adopt any of the ruling. Only the federal government can do that. There are exemptions at the state level. They cannot adopt for things like workplace harm center permutations, solves the entire need so that residents run on the advantage level. Solves is important because this is an issue of sphere injury in states level. The United States, the Dr. Fairless, such as parallel toward immunity.
453.